What state has jurisdiction over custody matters? I'm John Henderson with HH Law, and that's the topic we're going to talk about today. So out of the gate, it's hard to tell which state has jurisdiction in custody matters. Very easy if both parents are living in one state, like both parents are in South Carolina. South Carolina clearly has jurisdiction, but what happens when one of the parents moves with one of the children, or if they've been moving around a lot? To help determine which state has jurisdiction when it's not entirely clear, there's a federal law, the Uniform Child Custody Jurisdiction and Enforcement Act, and that basically outlines which state is going to take over and have custody. So right out off the rip, the general rule is this: wherever the child has resided for the last 6 months is the state that is going to have jurisdiction over the child. But there are a lot of different circumstances that might alter that and change that. Some of the examples of where the UCCJEA may not apply, that federal statute may not apply in an emergency circumstance, or if it's not entirely clear what the home state was for the child. Typically in family court, what we're looking at is domicile. That means not only is that where the child is and living, but where the child intends to remain. We think about it in terms of adults a lot of time, the custodial parent, where that person intends to remain. But in this context, a lot of times it's hard to tell. And that could be because the child has moved around. Colorado for a few months, Texas for a few months, living with an aunt somewhere up north, and then back to South Carolina. And maybe some of that occurs during the summertime, and it's not entirely clear. A child now is living in Tennessee for the past few months. In the summertime, we don't know because they went to school in South Carolina, whether or not they've actually moved there or not. Anyway, that's why the 6-month rule is very important to determine what is the home state, where has the child lived for the last 6 months. Outside of that, there are considerations like this: an emergency circumstance. Maybe something has happened, social services has had to intervene, or that there has been some sort of criminal issue going on with the custodial parent that might warrant some sort of intervention. So, for example, if a child is living in Connecticut, but they last lived in South Carolina, and the parent in Connecticut now gets in some sort of legal trouble, and there's an emergency hearing, rather than going back to South Carolina, they might hear that case in Connecticut to try to determine what to do with that child under those circumstances. And when it comes to an actual custody order, let's say in the state of South Carolina that a judge has issued an order, that court is going to maintain jurisdiction usually throughout the case so long as nobody has agreed to move the child to another state. What happens there is that a South Carolina court, in all family law matters relating to children, child custody issues are modifiable. So that court is going to maintain jurisdiction so long as there isn't any reason to believe that the child, through consent maybe of both parties or in the order, has moved to another state. But that court that originally entered the order by default is going to be a one that does have the ability to modify any future child-related issues. There are a number of circumstances under which the UCCJEA will apply, and we can hear them on the phone right out of the gate. For instance, when we have unmarried parents, and one parent lives in North Carolina, one parent lives in South Carolina, and it's not entirely sure which parent should get jurisdiction. Immediately, we are thinking the kind of a law might apply, that we're going to be thinking about what the jurisdictional issues are. That's very different than the circumstance where both parents are married, they both live here, and then we're going to try to enter into a custody agreement and then have it become an order of the court. And then that would lay the foundation for how we would navigate future child-related issues where the child might live and whether or not you have permission to move to another state. In that context, there would be an agreement entered in through the court, and a lot of times we negotiate under those circumstances what are the terms under which mom can move with the child or dad can move with the child to another state. You could have a dad, for instance, who is in the military and is moving around. You could also have a circumstance where we know beforehand that mom might be accepting a job in another state, or there's some triggering event that maybe the parent who is intending to move has to notify the other parent 90 days or more prior to that move, and immediately goes to mediation. Maybe the mediator who did the divorce and custody settlement, they would go back to that mediator for a half a day or a full day mediation to try to determine what are the future rules for custody, visitation, child support, and all those other child-related issues. If you have any questions about the jurisdiction of child custody agreements, we're happy for you to give us a call. Our number is 843-212-3188. If you were in the state of South Carolina, these rules apply to you. These rules also apply in a lot of other states, but be sure to contact a lawyer in your local jurisdiction for more information. I'm John Henderson, and this is HH Law.